down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Muted. Hello, everybody. Yes, please do remember to clock in for your shift. Tin Man's here. Gecko Chaser's here. Mayor is here. Hi, Mayor. Thanks for the shout out earlier. That was so wonderful to see you in Judge Fleischer's court. That's so fun. I got the vibe that they were Court Vibes fans, which is great. But I'm so glad that you were there. I hope everybody's having a wonderful Friday night. We're only 3 minutes late. I didn't even realize I was 3 minutes late. I didn't. I hope, like I said, everybody's doing well. Cellulite Yoga Pants still on her vacay. Came by to say hello earlier. That's awesome. Jelly Beans is here. Vicky's here. I love it, love it, love it. Erica, she's here too. Wonderful. Well, I'm feeling fresh and happy and excited for us. And yes, we have cleavage for Friday. We are, yeah, no lotion on my skin. Nigel's here. Sarah's here. Oh, but your Wi-Fi's acting up. Sarah, tell me about it, girl. But I don't have problems like that anymore. Luckily, knock on wood. Let's knock on that wood. Thank you so much, Casey Carey. So glad to see you too. Guys, we made it through the whole week. We did it. And guess what? It's Friday. So we are going to go watch a few things. We're going to start our way at some parenting squabbles with a judge wearing a bow tie. And then we're going to go to our favorite petty town, Thurston, and we are going to watch some small claims shenanigans. I don't know. We'll call it when we see it. How about that? Please do clock in for your shift. That's important. Let me pull up the case that we have here, our title case, the one that was on the thumbnail. Behemoth Monkey. Hello, hello, hello. Are they evil shenanigans, Paul? I don't know yet, but we will find out. Sorry, still getting used to the old system again. Give me 1 second. Oh, we did it. We did it. We did it. Chat's up here. They are over there. Paisley is right here. Katie9, thank you so much. Mayor, passing the word of the good Lord of KCC. Well, to be honest and frank with everybody, there will probably be a little more interaction like that because coming up, we are doing that football pool that I think Judge Fleischer is a part of, along with a couple other YouTubers that you may know. And so that is coming up. I'm taking it very seriously. I'm gonna beat their fucking asses. I will trash talk them. Maybe we'll have to do it here so that they don't hear it, because some of them have delicate ears. Anyways, delicate. Does she not look like she is? I mean, I know it's paused, but let's just see. Let's see how we do. She looks like she's got this face just stuck on her. And girl, I know how that is. You have to be very expressive. All right, let's go.
Morning. Can you hear me all right on Zoom?
Do what?
Can you hear me okay on there?
Yeah.
Okay, very good. All right, we are on the record. I do have Mr. Olson is present in the courtroom. I do have proposed orders. Did you have a chance to see these, sir?
The parenting plan?
Yes.
Yes.
Okay. I looked through this prior to court. And this does include the attachment at the end, which was the recommendation. Do you have any, is this, I understand you don't necessarily agree with this, but you understand, you agree this was what I ordered?
Well, I wasn't sure. Okay, I knew that you ordered a parenting plan, and I don't know how this works with me not having an attorney, but going over it and whatnot.
Mhm.
I'm totally not agreeing with it. And so I don't know what my next move would be with that.
Well, the last page, which is the time back.
Ooh, I know the answer. I know the answer. You're gonna do terribly without an attorney. And it's going to be bad, sir. You should get an attorney. Also, yes, Casey Carey, it's always 4:20 around here. Always on time. I'm smoking, what am I smoking? Watermelon gushers. Ooh. But seriously, right? Like, especially when it comes to children. Guys, get yourself a lawyer.
Back to unsupervised time, that's directly out of the recommendations from the Guardian.
I'm sorry, what? No.
The last page that's attached here has this timeline that was in the Guardian ad litem recommendation, or the investigator recommendation, which was what I had adopted.
Oh, okay. I see what you're saying. Yeah.
So essentially that's what you got to do, that, and then you're back to a normal parenting plan.
Well, this parenting plan that she has drawn up isn't anything what
Take a look.
the investigator had done.
She looks like a mannequin. Doesn't she look like a
I
mannequin?
mean, there's like changes on here. She gets him every 4th of July. There's
If there's something I've
You
learned
think
from
not?
watching these custody cases, it's that y'all Americans fight over the 4th of July. It's almost more important than Christmas for some reason. It's such a weird one. I don't know if it's just because we watch a lot of Michigan court and maybe like you go to the lake or whatever, but it's just you can't get around it. So he's alleging that she's trying to steal the 4th of July forever and always. Mac the Knife, I was in Florida for like a month last year, so I was allowed to say y'all. Actually, I'm trying to assimilate. Maybe one day my dream will come true and I can go to America and follow my dreams.
here that are to me like ridiculous. I don't know where this is like going, but I'm losing more and more time.
See here, Ms. Steinweg?
Mhm.
Oh, I'm sorry.
Oh, that I have to have my mom supervise school events.
Yeah, that was brought to the court's attention many months ago, and that was agreed on by the judge.
Right, the very last page, which has all the supervision requirements, that's based on the drug usage. And that, I mean, that's just a problem you're gonna have to deal with, sir. I mean, that was the concern that was raised throughout this case. Let me just take a look at something else here, just a minute.
All the other visits besides summer and the 4th of July are the same visits that were in our last final parenting plan. I set them up according to our regular parenting plan, the same years, odd years, even years, everything's the same besides the summer break. And that's every other weekend, like I was told to put in there.
Let me just take a quick look at your one thing. I was just,
We celebrate July the 1st, so It's fine. I'm putting my Coke into my. Oh, what are you shaking your head for, Judge? Don't be done until I'm finished pouring, please. Thank you so much. I've put my Coke into my Baba mug with ice. So lovely. Oh, it's gonna be so good. This is my treat.
Looks like under the original parenting plan, the 4th of July would have been following the summer schedule.
My family has had a family reunion every single year my entire life. And every time it's a game, whether Zach is able to go or not. So I did include that.
humble brag every single year of your entire life, Tiffany? Okay. Firstly, I will say prove it. No, seriously, guess what? When you have to share. Don't plan those events on super holidays that have to be shared. How about that? Tiffany? How about that? Do you have to celebrate with America too? Is that the problem?
That day so that he could be with my family. But if that's not okay, then you're more than welcome to change that.
I'm just looking at what your prior parenting plan said. What it said was 4th of July essentially followed the summer, and the summer was alternate week on, week off during the summer. Of course, that would happen after we get past all the supervision. So
Okay, but what was agreed to was every other weekend. Even in the investigator's report, she said that after.
She said, "Thank you, Mark." Oh my god. Oh my god. Oh my god. Oh my goodness. Oh my god. Oh. Ah! Wild child. Patrick. You guys, this is so exciting. Thank you so much, Mark. When will it end? I hope never. I hope never. I hope never. Oh, it ended with Christy, but it was amazing. Ah, that is like a jackpot, like a slot machine. It's the best. Mark, you're amazing. I wish I could highlight your comment, but I can't. I don't know how to do it. I didn't learn today. That was on my to-do list, but I didn't write it down, so I didn't do it. But thank you so much. I see it. I feel it. I love it. Yay! Yay! Ah, I knew I dressed up for a reason. Thank you. You're so sweet. Yeah, Charlotte has left the chat. Okay. Oh, we're watching court, right? Sorry. Yay!
After he were off of the drugs, which he hasn't provided a clean UA yet, it said every other weekend. It did not say going back to summer is a week on, week off.
just take a look here.
Oh my gosh. It tastes like vacation. Except I have a hair stuck to my. There we go. Tastes like vacation. Ice cold Coke. Virgolicious, I like your name.
All right. Okay, I see that.
Judge, sorry. Oh my god, you guys, I have some amazing
This
news
has been
to
going
share
on so
later.
long, and he's yet to fail or to provide a clean drug test to me. So it's
Your Honor, I do have a clean, well, I didn't get one to her because they were supposed to let me take another UA this week. And my treatment facility is like flooded with people and they're overcrowded, and I've like had 2 nervous breakdowns down there this week trying to get them to help, but it's not. It's because I've moved up that I'm only supposed to go twice a week, and like my groups have been cut down, and so it's like, honestly, the first time in my life I need to take UAs that they're not giving me the UAs now, but I do have, and I turned it into the courts. You should have got a recent copy. I didn't send Tiffany one because I was hoping to get like one yesterday or today, and it didn't happen.
All right, well, I do not have anything here. If you've got a clean way and you've got 45 days clean, then you fall under that provision where it's unsupervised time. So, I mean,
My,
what you just need to do is follow through that last page because that's what I ordered.
okay,
But the last time we were here, he said that his last drug tests were not clean. So that would not be 45 days because we were here less than 45
No,
days ago.
I understand that. I'm just saying that there's timelines. You have to be clean for a while.
right,
And when we were in court last, you'd indicated you'd had a relapse, and
yes,
so that's, you've got a substance use issue, sir, and you've got to
7.
deal with that. And this is the result of you not having done that for a long time.
I'm
And
sorry.
you get yourself clean and you demonstrate a period of that, you can always come back and we take another look at it. But this thing has gone on, I followed this now for a number of months. It's been like 6 months in hopes we'd kind of walk you through this and be able to put this together. And the result is you haven't been able to do that. And I'm not upset. I'm just telling you there's a requirement. You need to be clean for your kid. And so that's where your focus needs to be. And so I am going to adopt this order as is proposed. And it seems to me, based on the recommendations we had, again, we've been bumping along for a very long time now. Normally, I would have entered an order back in January. And I took this case a little differently because I was seeing some progress. And I understand addiction. Addiction is kind of 2 steps forward, 1 step back, 2 steps forward. But you need to make all steps forward before you're going to be out of this.
And can I say something really quick?
Sure, go ahead.
Miss Gunter was concerned about sport events on Saturdays and picking up on Friday evening. And can you give her a chance to talk? Because she was concerned that they're going to pick up at 6:30 on Friday, and then some of his sporting events will be on Saturday morning. So he'll need to be transported back to Jewel to the bus to get to his sporting events.
Mhm. So
I was just wondering if you could give her a chance to speak on that.
So first things first, we need to talk about the hats on the walls, okay? Katie9 brings up a really good point. Do you think she wears them? My answer is no, but I would like to say that when I was a child, my mother was in a very fancy wedding where she wore like a really, really fancy dress and a big, big hat, bigger than those, like white, very weird. Anyways, and it lived on the wall in my Nana's apartment, and I used to take it down and play with it quite often, much to the chagrin of them. And now I laugh about it, but I'm sure it was expensive, and it was probably like, I think they rented the dresses but they bought the hats or something. Anyways, but I just think of that when I see the hats on the wall there. They weren't cowboy hats. They were like really like weird. I'll try and find a picture. I might actually have a picture.
Because she's going to be the one doing transportation if he is unable to have unsupervised visits, then it's going to have to interfere with her schedule.
well, I can't fix those things. Those are,
Okay.
you're gonna have to work around. What
Okay.
What I think he also, and I want you both to understand this. This is the parenting plan we will enforce. In other words, this is what sets out your rights in the plan. If the two of you come to some agreements to adjust timing, adjust anything else, you can always do that. You're not getting in trouble on either side with the court. This is what we'll enforce. But you can agree to do whatever you want. So as this thing moves forward, if you can demonstrate that you're clean, you're not using for an extended period of time, the two of you can agree to whatever you want to, but you've got to come to the table first, and that means getting yourself off of the substances. Okay. And ma'am, I appreciate you being here. I know this puts a lot of weight on your shoulders to provide transportation and things. That's kind of where he's at.
Yeah, I can't do the 3-hour drive, yeah. I know that,
Okay, well, if you can't provide that, then you're gonna have to get some alternative set up to that, but that's,
we are, because, that Miss Mountain is not
Mhm.
something I'm gonna do in the dark. In rain, I'm not, and, let's have a cleaning report for more than 90 days or, in advance.
well, if he's got that, he can provide it, then he falls into a different spot on this list. I haven't seen that, so, and I don't think she's seen that, and she's the one who needs to see it. So, but the problem is that the last time we were in court, there was a relapse. That's what you told me.
That goes back as far as May.
This shows a positive UA in June of this year.
That's my relapse.
Right, so that's not 90 days. This is July, August. That's not even, that's 60 days. So, I mean, I'm just looking at, this is what you got here, and you got one that shows positive in July 1st. August 1st, September 1st, you're looking at October for 90 days. So I'm just, I'm just telling you, this is what you've got. You've made decisions along the way that impact what your rights are. Okay. So stay in treatment, keep following through. You've made some good progress, but you've got to get it completely under control. Okay, I've signed that order.
Your Honor.
Yes, ma'am.
Also, if he is unable to get his drug test through the treatment center, he's able to go to another provider where they could give him a drug test and provide.
There's all kinds of drug testing
Results.
agencies. Any state certified drug testing agency would be appropriate for the court. It doesn't have to be where you're in treatment. It's a state certified drug testing agency. There's people that do them for employment drug tests. There's people that do them. Treatment agencies do them. So as long as it's a state certified provider, that's fine. So you can go anyplace else if your treatment agency won't do it. Yes. Sure. Yeah. Okay. So I've signed that order, and I wish you both the best. And I urge you to keep following through on your treatment, sir, because you need to be there for your child. And the goal really is to make sure you're there clean. Okay.
Thank you.
I've signed that order.
Okay, well, I mean, fair enough. That is what we want. Hi, Beverly. Give me 1 second to get our next docket up. I thought that was an interesting case. It just seems so just the way it is. Oh my god, this looks like a clusterfuck already, folks. A clusterfuck, which we love. We love clusterfucks. No worries if you're late or if you just got here. That's okay. Welcome to my kitchen. Tell me what you had for dinner tonight, or if you didn't like what you had for dinner, tell me what you wish you had for dinner. It'll pop up over here in the chat, and I'll read it too. But in the meantime, what we're going to watch is Small Claims Court. And we're not going to watch the part where the judge tells us, please don't come to trial. We've skipped that part. So, a zippity-doo-dah, here we go. Zippity-doo-dah, zippity-day. My, oh my, what a wonderful day.
anything else I should consider before I talk to Ms. Jordan?
I mean,
It's a compromise of a disputed, but not. And so after you filed this claim, looks like you came to some settlement with USAA, which is
I went too far.
Um,
Here we go.
Ms. Jordan's insurance company, and about this date of loss, April 13th. And when I read that, you got $10,000. All right, so in consideration of payment, the receipt, you acknowledge receipt of that payment, you hereby release and forever discharge Monica Jordan from all liability for damages to any and all property resulting from collision occurring on April 13th in Lacey. And it's expressly understood that this release applies only to liability for the property damage which arose from the above stated event. And this release does not affect other rights, causes of actions, or demands that you may have for other damages, included but not limited to personal injury or other claims that have or may arise out of the other events or contacts. I'm not sure what that means. All right. You're agreeing and understanding that's a compromise of a disputed claim, and the payment's not construed to be an admission on the part of Ms. Jordan. All right. So that's what I kind of reviewed. And is there anything else so what I understand, you think that I should interpret that, that she is released from all liability for damages and all property resulting from this collision, but that would not include car rental.
correct, because that's not property damage. That would be an
Okay.
expense of that's, yeah.
All right. And in your discussions with Ms. Jordan, did you have any discussions with Ms. Jordan about that car rental and how what
No,
was there a dispute as to that being part of the property settlement or part of this insurance settlement or
no,
not? Or
I've had no contact with Miss Jordan other than through this court.
okay, well, that's too bad because it's always best for people to talk. But all right, so anything else I should consider before I talk to Ms. Jordan?
I mean, I've asked a witness that was there to the incident to join us today so that, in case there was any question as to who's at fault for the collision.
Okay, so that's Amber Hardkey.
Yes.
Okay, and Ms. Hardkey, let me have you unmute and find out if you're really a relevant witness here. Raise your right hand first. I need to put you under oath. Ms. Hardkey, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, so you would be a witness to the accident itself?
Yes.
Okay, were you involved in the USAA insurance issue?
No, Your Honor.
No, okay, so, all right, now I know where you are. Let me jump to Ms. Jordan first and kind of figure out the landscape here. Ms. Jordan, so that's what his claim is. Mr. Eastman's claim is for the $666.45 for the car that he had to rent. He put that information in the court file, and the car that he had to rent while his vehicle was being worked on after the collision. What do you say about that?
It's my position that the car rental is related to the damages, and also that in the car rental agreement that he put forth, it says that $200 of that was collateral that he would have returned. So it would be $466, I believe. It said that there was a $200 collateral that was returned.
So
But
even if the court found that the insurance payout didn't include the car rental, you're saying, do you know where that is in his documents?
it's in the car rental agreement, he says less $200 collateral.
Yes. Minus 200.
Nails
So
here.
that would be,
One second, Mr. Eastman, I'm talking to Ms. Jordan. So
All right.
how do I get thumbnails? You know what I mean? View, maybe that's it. Know what I mean? So that I can have this side of all the dots.
I don't know what you mean, Judge. Also, the AI summary is hilarious
Pains?
usually. Also, does anybody have a Ninja Creamy? I want one. I'm thinking about adding one to my wish list on Amazon. I'm really hoping Santa checks that this year. That's like
Yeah. it's
pretty
working
important.
for me. Maybe it's.
Santa or my future husband. Oh, Mike, you're terrible. I love it.
Oh, well. If you can figure it out, that would be great. I'm just gonna keep on keeping on until. Okay, let me get to that. And then I can talk to Mr. There. No, that's.
Mark.
Here are all your documents. Just give me one. Come on.
Oh, you guys. The Ninja Creamy takes just 24 hours, I think. You
Works
freeze it
nicely
and then you make it
on
in the
my
machine.
computer in my
And it can make
office,
so
but
many
here for
things.
some reason
And you can make almost anything.
All right, so I'm
into
there
ice
at the
cream.
enterprise rental agreement and summary. And Ms. Jordan, where would you point me as to that issue, $200?
Oh gosh, I think it was in Mr. Eastman's writing where it says less $200 collateral.
Hmm. Yeah. Yeah, you're gonna have to help me out with that. I have the enterprise in 2 pages. They're page 9 and 10 of the documents. And I just see signatures and.
Let's see, hold on, I'm sorry, I'm pulling it up. It was in the it says table of contents. On the
Up
table of
there.
contents page, under where it says car rental fee, it says $200 minus the $200 for collateral.
Okay, so we'll talk to him about that. I see. All right. So the first question seems to be, all right, so you believe that the amount that USA paid out covers this as well, and if not, then it should be 466.45 to figure out what that 200 is. All right. Anything else that I should review? Anything you want me to take from the release that you signed from USAA to support your point of view?
I'm not familiar with who the witness was. I know I was there. We both pulled over immediately from where the collision happened because it was right on we both parked immediately right there. And I was there.
Are you disputing, I guess the question is, you disputing that this happened at all and that you were there and a driver? And
I'm not disputing I'm not disputing that the accident happened at all. I just don't know who the witness is because I was there until Mr. Eastman drove away and no witnesses presented themselves, so I don't know who they are.
Right. Well, it seems to me that Ms.
fine.
Hardkey would be not relevant to our issue of whether the insurance covers this or because she wasn't part of that discussion. I think that's been settled. And I appreciate that she's here, but it's not relevant as to whether the collision happened. We've got that settled. Okay. So then so then looking at your insurance settlement, when you did all this, anything you want me to know about that or I turn back to Mr. Eastman about that 200 potentially?
No, Your Honor.
Okay. So, Mr. Eastman, what is this in your table of contents, that $200 that you're talking about?
Yeah, Ms. Jordan is correct. There was a $200 collateral. I ended up having to pay $666.45. But then upon return, there was a $200 reimbursement. So that brought it back to $466.45. And then
Okay,
after
so
the
you got
filing
those
fee,
$200 back. So you were out $466.
correct. Plus the filing fee and all that. But
Well, we'll get to that if you do that, but
I understand.
the principle is what I'm talking about here. So it's 466.45 potentially. All right, so just re-reviewing USSA's agreement that you all signed. Yeah, all right. So my interpretation of USSA's release here, and certainly it says release for property damage, but then we have to go into the guts of it. I don't find that, I find that the car rental, that 466.45 would have been covered by this $10,000 that you received. And the reason being is the statement here that you're releasing, you hereby release and forever discharge Ms. Jordan from all liability for damages to any and all property resulting from the collision occurring on April 13th. So all liability for damages to any and all. And so all liability would include naturally a car rental need, if you had to expend money to get around while your vehicle needs to be fixed. So that's what I'm finding from USSA. That's what I'm finding in the interpretation of this. That's what judges do, is we have to interpret contracts and what you signed here.
Right.
So in that way, Mr. Eastman, you've been paid, so I'm dismissing the claim, and there will be no further money on small claims issued that Ms. Jordan owes you in this case.
May I speak, Your Honor?
Well, you already did, and I already made the rulings. So if you
Thank you.
then, all right, so long.
So long, farewell, I'll be to saying goodbye. I did not get a sunburn. It is not your imagination though. It is a filter that I use. I affectionately call it "Don't look like you're dying." I turned it off yesterday. There's a fun little thing for you if you really want to find it. When I turn it off, I look like a ghost. So I got some sun, like obviously because that's happening, but it is exacerbated by the way we do. Yes, Pacey Paisley, because I'm actually very sun conscious, as you can tell. I am very pale, to be honest. Anyways, but I have been trying to get vitamin D via the sun, especially for cholesterol, I read about. Anyways, something like that. Regardless, let's let the judge continue to break hearts today, deny claims. She just gave somebody the big D. Bam.
And Ms. Jordan, you can be on your way. This judgment will be in the court file for both of you.
Thank you, Your Honor.
What happened? Did somebody fall there? Oh my gosh. Oh yeah, and I'm Scottish. I sounded weird saying it there. I was born in Scotland. I'm Scottish. It sounded like somebody fell there. I was just about to talk about how we were wearing the same
See,
sort of
Mr. Legrone, are you there? Mr. Legrone and the Fabians.
I'm
The
here.
Fabians. Okay, can you start your camera, Mr. Legrone?
Do you really think so?
Working on
Mark?
starting your camera, Mr. Legrone?
Start your camera.
Had it working before. I hope you can get that up again.
Yeah, a big black camera for you, Judge.
Mr. Legrone, you there?
I am.
Okay, you working on starting that camera?
It's should be up.
Yeah, do you have maybe a mechanical slider at the top or something like that? Because I don't see you, and you were successful before. And I need to have you as if
Uh,
I need to be able to see you and hear you.
Judge, I'm willing to act his part
Not
out.
some sort of
if that would
mechanical
be
slider
easier.
at the top of whatever device you're on, or?
No,
Huh.
ma'am.
Well, Zoom is an alternative to in court, and we rely on it a lot, but it has to be in a way that everybody can see and hear each other. That's a little bit of a problem
If there's anything
today.
we've learned over the years.
I actually have an issue that I need to clear up. Maybe that'll clear all this up. Mr. Legrone, I'm going to try and just at least deal with the venue issue, or if you're in the right court or not for your claim. You live in Tacoma? You're a resident of Tacoma?
Yes.
Yeah, it's going to be a little odd, Mr. Legrone. I'm going to try and put you under oath. Would you raise your right hand with me?
Okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, and then Ms. Fabian, if you'd raise your right hand with me, you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, and then Jeff Fabian, if you'd raise your right hand with me, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, we're not going to get very far today, frankly, but the one issue I want to try and clear up, which I think might be dispositive, is this issue on venue. So what I'm seeing is, Mr. Legrone, you're in Tacoma, and then I see the Fabians, you live here, you're residents of Tumwater?
I am, but he is not.
Okay. Mr.
I'm-
Fabian, where are you a resident?
Shelton.
Shelton. Okay, so you're in Mason. You're in Thurston. And Juddville LLC, Ms. Fabian, do you know what that is?
So Juddville LLC.
Jugville LLC? Is that what they're saying? Jugville LLC? That's right here, Judge. Can't you see? Kevin and the Jugs are zooming right in.
LLC doesn't exist to my knowledge. Juddville 1 LLC is an LLC that owns the neighboring property to Mr. Legrone, and it is one in which Jeff and I are members, but are not the only members.
Okay. All right, so there's a different entity called Juddville 1 LLC. And so there is no such thing as Juddville LLC. All right. Maybe that's why. How did you receive notice, Ms. Fabian, of today's hearing?
Yeah, I received service to my residents in Tumwater.
Okay, Mr. Fabian, how did you receive notice of today's hearing?
My sister told me.
Okay, and that your sister Susan. Okay.
Yes.
All right, but as well, Mr. Fabian, Juddville LLC, what can you tell me about that?
There is no Juddville LLC.
Okay. Now there's something similar called Juddville 1 LLC.
That is correct.
And when your sister tells me that you are both members of that, what does that mean?
It's an LLC that was formed to maintain properties for our family.
Okay. So there are other folks who are in this LLC. All right. Are either of you an officer, a president, secretary, treasurer, Mr. Fabian, anything like that?
We're all I believe we're all just equal. We each own 33% of the LLC.
Okay. All right. And Ms. Fabian, that's what you understand?
I've always understood it to be just that we're all members.
Okay. And a different Juddville 1 owns property next door to Mr. Legrone.
No, the Juddville 1 owns the property, and that is the one, so Juddville 1 is the property owner, and we are Juddville 1, but we are not all of Juddville 1.
Yeah. And you're not Juddville LLC. Okay.
Right.
All right. Well, and then, all right. Well, Mr. Legrone, sounds like you got to get the right defendant. Sir.
Can I say something, ma'am?
Sure.
From the Tacoma courthouse that we tried to serve, we went there to fill out the paperwork. They said it is Juddville LLC. Online, they are also known as Juddville 1 LLC and Juddville 2 LLC. And it says Susan Fabian is the secretary, or, you know, like she's the top person of this LLC. That's why we served her first and foremost.
And this is about a property claim in Pierce County, your
Correct.
property claim up there.
Yeah, but we were told that
Okay.
we needed to file in Thurston because she lives in Thurston.
Well, that sounds right. Do you have anything from the Secretary of State here that you filed in your documents? I'm looking. It tells me that you got the right person here or the right entity. Looking through your documents, Mr. Legrone, to try and figure out, I didn't remember anything from the Secretary of State or any proof of these folks are the right folks.
For what? For which one?
Well, they would have to be registered with the Secretary of State, and I don't know, you're saying you looked at some documents that you said that in fact Susan Faboni is Fabian, sorry, is Juddville. They're asserting they're not, and I'm wondering what documents you may have filed in your exhibits with the court. And I didn't remember you did file anything about that nature. Did you? Is there anything? Secretary of State
yeah.
documents, business documents, anything?
Business documents, I believe it was. Nothing,
All right.
I don't believe it was the Secretary of State.
I didn't see it in the things you filed with the court. I see pictures in your handwriting. Am I missing something?
I don't know what you could be, you know.
Well, you would have filed it or not, and so that's what I'm
I would
asking
have,
you.
yes, correct, and I did file it.
And what does it say there? I don't have
It
it
was a
here.
printout of the LLC, her name, his name, and, you know, it was from the state of Washington.
Okay, was that the Secretary of State, maybe at the top?
I couldn't say for certain.
Without, I can't get through these exhibits. I need to somehow figure this out, because I can't get through these. You, pains, yeah, and then I get thumbnails. Finally, but then I want.
What are
Okay.
they talking
Yeah,
about?
there isn't anything that you filed from any entity. You filed a lot of text messages, pictures, and your handwriting. So you're asserting that these are the right parties, and they're asserting they're not. So
No, they admit that they're the right party.
no, they don't. They say they're not. That they're a different Juddville 1 LLC, that they're family, that
they're-
they don't have authority to bind. They don't believe they have authority to bind. What I'm going to do here is I'm just going to set this over and give Mr. Legrone an opportunity to collect that information. I am kind of thinking you're also, I don't know why Pierce County told you Thurston County. I understand a bit, but this is about property in Pierce. We'll continue this on, but I think you need to look into the Secretary of State filing and make sure you get the right folks. And at very least, Mr. Legrone, get that information into the court if you do believe with authoritative documentation that these are the folks that you should be suing. And if not, then, but I want to give you that opportunity. So I won't dismiss it today, but I'll set this over to give you that opportunity. In the meantime, you can still talk and see, but if there's other people that need to be sued or in a different way, do that. But I won't dismiss it today, but I'll give you that opportunity. We'll set it over.
I'm a little confused when they say they own the
Well,
property behind
They're
me.
saying they are not the ones that can speak for Juddville. They can only speak for Juddville One LLC. So you get that proof into the court, and also make sure next time that you got a working connection or just come into court. All right. Because we
Yeah.
can't have a hearing today anyway, because I can't see you, they can't see you, and it has to be as if you're in court. So what day are we looking at?
Our next date would be October 4th.
We're looking, you do these on Friday morning. Everyone can look at their calendars. October 4th is our next day and thereafter. So Mr. Legrone, October 4th.
Sure.
Okay. And then Jeff, Fabian.
Yep.
And Susan, October 4.
Checking my calendar, I'm sorry.
You're gonna make it work, Susan. What the fuck is on your calendar, Susan?
Okay.
Okay, October 4th it is. Nobody has to serve notice, at least among the
Shocked.
three of you. But Mr. Legrone, like I
Sir?
said, they're saying they're not Juddville LLC, and they can't bind Juddville One LLC. So you got to get that figured out. We'll give you this opportunity to do that. Come back. Fourth, I would expect. And if you find these aren't the people, then we can dismiss the claim and you can go after who you think you need to go after. But
I recognize them, so I know they're the people, but
well, I suggest
I'll
confirm that.
do it then.
A heads up, Mr. Legrone, in with air, and they're saying this, be in the same spot, and they'll get dismissed. So
I
you got
gotcha.
this. So we'll see you on October 4th. So the Fabians can be on their way. Mr. Legrone can be on your way. We'll see y'all October 4th.
Your Honor, may I ask a question?
Yeah.
Clarification. So if it's somebody, like, if we're as individuals the ones named, and so we as individuals appear again, would we be notified if it was changing who is being?
You would, yeah, be here October 4th, and we'll find out what's going on, unless he decides, unless Mr. Legrone asks the court to dismiss the case and he files under a different cause number.
Okay.
Yeah, you can always call the court, but be here October 4th.
Okay, thank you.
All right, that's
Thank
it
you,
for
Your Honor.
today. We'll see you October 4th. So where are we now and everything?
Yeah, where the fuck are we at, Judge? Are you fixing your computer or are you looking at your docket? Those are my questions. Okay, this is the size I'm supposed to
Start from
be.
the
That's
top
what
and move
Barbie
down.
said.
Yeah,
Okay.
and then the participants and then Stephen.
Talkity talk, talkity talk. She talks, talks,
We'll find out what happened.
She gets
Okay,
some
well,
help and then
we'll
people
see
sit down.
as we get to it.
Looks like we'll skip ahead.
Just got lucky.
Look at
I
her.
have no idea how to get there again.
Tech
Thanks.
support.
Thanks, Trace. Take a vacation now. All right. Trace got me there.
Oh,
So
fucking
our
genius.
notice, I gotta get to the notice. Is it working? Somewhat. Okay.
Ladies familiar over there at the table. I'm a genius. Did you see how I put that?
All right,
video?
so Ms. Robinson, you filed this claim under 37346 against the Rainier Board of Directors Homeowner Association. We've got Mr. Campo here. Mr. Campo, you're allowed to bind the Homeowners Association in litigation?
Yes,
Okay, and what's your capacity?
I'm the treasurer.
Okay, all right, so you're an officer. And so, Ms. Robinson, you say you're owed $2,500 for the destruction of property. I had a chance to, before court, to look at everything. I've got it all here too. And it looks like it's about trees or, not trees, but what are those? Hedge and.
Bushes. They're bushes.
So the $2,500, if you can give me a summary, I'm kind of probably going to interrupt you as we go, just as I get clarification on things. So don't take that personally, but 2,500 from the homeowners association. What's the $2,500?
Well, they destroyed some of the landscaping on my private property. And I consulted with a professional, unbiased tree service. So someone not employed by the HOA to assess the damage and provide feedback and recommendations. Since I hadn't heard anything from the HOA, they just ignored all of my
So these were on your
emails
private-
and
they're on
knocking
your-
on their doors.
These are on your property and
Mhm.
owned by you, not by the HOA.
Correct, but the
Okay.
HOA
So
maintains
what's
that
the
portion of my property.
$2,500? What is that gonna get you?
Well,
My $2,500.
yeah, so they damaged some property, and even though I don't have the power to replant, it did, in my opinion, lower the property value. It made my property ugly. I'm trying to sell and move.
The 2,500, I'm still trying
Oh,
to get
okay,
that.
so I was starting to tell you that I called a tree service that came over to assess it, and they looked and said it was destroyed. That's in my evidence page. I don't know if you've looked at any of my evidence.
I did, and you can redirect me.
So page 27,
Okay, let me get there.
he came over, met with me briefly, gave me his card. He said the hedge was destroyed and should be replaced. I asked him if it would regrow, if it was really destroyed or just look bad. And he said, actually, it would regrow, but he said it would take 10 years to look decent. So that's why he was recommending it.
And so he is who?
He is not affiliated with the HOA. He's just a
Who is
private.
he? Who's he? What's his name?
Oh, sorry. His name is David Drury.
Okay, so he's a double
D Tree.
David
He and his
Drury,
wife
alright.
own the property. I spoke with her on the phone.
Alright.
So Karen and then David came to my property
Alright.
on May 28th.
And this happened when?
The bad pruning happened in late April. I think on the 26th, I believe. I'd have to double check that, but I took photos on the 27th.
Of this year.
Correct, and I
Okay.
immediately emailed the board and our property management company to alert them to the damage and in hopes of containing it. I saw the person doing the pruning. I knew he wasn't a professional, even though he worked for the landscaping company that HOA employs.
So is it pruning or you've got pictures of stumps?
Yes, so first it was poor pruning, and as time went on, about 6 to 7 weeks later, they were cut down to stumps.
So I'm looking at your picture, number 4, I think. it's
Mhm. I
titled
took that in
here.
late June. So,
So there's a couple of occurrences then.
right,
one
they
in
were,
late
yes, it was a
April.
progressive removing of the 4, well, they're actually trees, but they grew together and looked like one big hedge.
All right, so in April, there was a pruning, and then in sometime later, June? you
Yeah,
said?
in June.
There, those 4 stumps.
Yeah,
that
I
those
didn't
were
see them
taken
cutting
out.
them down to stumps, but I came home one day or I went out of my house and I saw the stumps. Um,
And what communications did you have before all this started happening with the homeowners association or?
Yeah, the day after I saw him miss pruning initially in late April, I emailed, like I said, I emailed the board of directors and the property management company. And that is, I direct you to, I have a script, and so we're going out of order, and so I'm having a hard time putting all the pieces together because there's over 30 pages of evidence.
Right, there's a lot of, and so I need to hone in on things, so.
Well, it's all relevant, in my opinion. So, sorry.
How long is your script?
It's one page or three-quarters of a
Okay,
page.
why don't you go through
Should I
that
just
and
read
then-
it? And
yeah.
that way I can point you
Yeah.
to pages and it's a
Why don't you just
coherent
go through
story.
it, We'll come back.
Okay, appreciate
Alright.
that. That makes it easier. Okay, so I filed this suit due to what I believe are breaches of fiduciary duty by the board of my homeowners association. It's called Rainier Park. also known as Breckenridge. You will see references to that in the emails. And it's located in Southwest Lacey. I've owned my home for 5 years. And so I'm going to walk you through all the evidence, which is 30 plus pages. So the first breach, which you were referring to, the
Let's go through
pictures.
your whole statement and then let's go backwards, because then I'll have a big picture.
Okay, good.
Focus in.
Okay,
Yeah.
the first breach occurred in late April of this year when I saw an unfamiliar landscape worker unprofessionally pruning an arborvitae screening hedge in my front yard, which the HOA maintains. And you already referred to those pages, pages 2 and 3 show. I actually saw him doing it, but I didn't have the power to stop him because the HOA is responsible for that. Even though it's my private property, they maintain it. The CCNRs on landscape maintenance, plus a diagram of my lot, number 196, are on pages 31 through 33. So you can see what my lot looks like and understand that the HOA maintains the front and front side yards up to the fencing. And I maintain my backyard behind the fencing. So this unsightly damage that happened on my property, as well as other similar other properties on my street, roughly a half dozen, looks like, hedges were butchered, affecting probably 9 homes. It was plainly visible for everyone to see. Anybody living on the street, anybody driving or walking down the street.
They butchered her fucking plant. Jesus Christ. They butchered her fucking plants, Mikey. They butchered her plants and her bushes. I know we do have condo associations, but not as many HOAs, only because I live in a place that's already sort of developed a long time ago. So there's no like housing developments right around here. Mikey, this lady's, I've got a bad feeling already. Her plants were butchered. Thurston County problems, right? You guys are so great. Oh, reminder, tomorrow night, slap fights, 8 p.m. Eastern on Credence and Mikey and Poor Sports. I'll be there. It's going to be fun. Mark it on your calendar. You have a date with me.
Would notice. The damage was unintentional. I'm not claiming that it was malicious, but the HOA is still accountable for damage to our property. Some weeks later, I saw a familiar longtime landscape worker. He's got white hair and a beard. I don't know his name. Pruning the other.
His name is Santa. I saw Santa. He only comes around once a year, Your Honor. He has a sleigh, which all his tools are in, and also reindeer. They accompany Santa once a year when he comes for my lawn. Oh, fuck.
Other Harbor VA hedge on my property. So there's one on the south side and one on the north side. And he was doing it properly, which typically they do a pretty good job. And most of the hedges on my street were pruned properly. It was just, I noticed in late April that about a half a dozen of them were not. So that I'm referring to pages 5 and 6. 5 is the other arborvitae hedge on my property that was pruned properly. I saw the landscaper doing it actually. And then page 6 is just 6 as examples of other properly pruned, the same exact kind of hedges on my street. From late April into May, I sent several emails to the HOA, but they were ignored.
Oh, they ignored her. Good night, Mayor. Thanks again for the shout out today. I'm so glad you made it down to Texas. Please be safe and have a good time. We'll talk to you tomorrow. We love you. I can imagine the HOA ignored her. God fucking damn it.
See pages 7 through 12.
So in April, there's pruning. And
Right.
then after that, well, keep going.
Well, yeah, I emailed them the next day because I was concerned and I wanted the damage to be contained. I mean, I knew that somebody out there was unprofessional, was doing this work, and I thought they should know and try to stop it, basically. But I never heard back. I have still not heard back from the HOA in any way until today when I'm seeing Mr. Campo, but that's not the same thing as replying. I also knocked on 2 board members' doors. I looked up where they live. One I knew, the other one I didn't.
Let's focus in on what you think the damage is. So first in April, you believe damage because of the pruning, and then
they were cut down to stumps.
and that was sometime in June, I think. At least
Yes, I took a
generally.
photo after I noticed that.
Okay.
I don't know the date it was done. I didn't see it, but it was sometime in June, correct?
So keep on with your.
Okay. But I wanted to emphasize that I did reach out to the board multiple times in person as well as email, and I never received a response, even acknowledging the issue. I also provided excerpts from the HOA meeting minutes beginning in January of this year through April, which was the last month that had been published when I filed this suit. And that's on pages 18 through 26. The reason I included that is it indicates landscaping leadership by the board was in disarray during those months. There was extensive turnover on the landscape committee.
Ew, she likes the HOA normally. The Landscaping Leadership Committee? The Landscaping Leadership Committee? If you live in a place that has a Landscaping Leadership Committee, I don't know if we can be friends. I'm sorry. I really don't. I'm sorry. I just don't think that we would agree on certain just fundamental things. Oh my God.
Poor communication between committee members and no landscaping reports. Normally the committees report every month or almost every month at our monthly meetings, and just no information from landscaping about what was going on. This issue was never mentioned as far as I have seen for the community to know. So in my opinion, it appeared that the board wasn't even acknowledging the issue. That's just my assessment based on, no information, no response, and nothing in the minutes.
So these are February. and
Well, it goes
January.
February through April.
Okay, April.
Yeah, April is when it happened. Of course, the May minutes hadn't been published yet. Before I filed, and uploaded my evidence. I did see them published about 2 to 3 weeks ago, and I read it, and it really still didn't mention this landscaping problem. It takes them at least 2 months to publish the minutes, so I don't know if it was ever discussed after that, but my guess is probably not. We've already gone over when the hedges were cut down to stumps. And again, this was not just on my property, it was on multiple properties on my street.
This is all about you, not anybody else.
Right,
so
right, right.
That's not relevant.
That's
All right.
true, but I have to look at those stumps as well. So I made an offer on a home I'm trying to move on June 30th. And at that point, the hedges looked terrible. And I think there were stumps at that point, and I was concerned that any potential buyers when I sell would see that and it would be off-putting to them. You always want your property to look as nice as possible when you sell, and it had been diminished in my opinion in terms of appearance. I also made an offer yesterday, which I wasn't accepted. And at this point, the stumps have been removed. There's just dirt, which could also raise questions by a potential buyer. So the cost to replace the arborvitae trees, I spoke to the owner of the landscaping company yesterday, and he said they're very expensive plants. So
They're very expensive plants. Didn't you know that? NPC, thank you so much. You're so sweet. I appreciate that. It is coming. That's what she said. Streamlabs We need to talk after your shift. Ma'am, you don't, like, if they didn't know they were there before, I don't know that it necessarily lowers the value significantly. Yay! Do, 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 do! Is that enough for a tree? Will that get me a tree? One of those trees? I don't think so.
He said he would put 3 in, even though there were 4 originally. And so, it's an expense. And then it's also an expense across my street. It's going to cost the HOA hundreds, if not a few
I don't
thousand
care about
dollars.
what's gonna cost the HOA on. some
But I'm
other
an HOA
property.
member and that's my dues.
So you have to show me why $2,500 is your claim. I'm still waiting.
Well,
to hear
that's
that.
page 27.
Okay. That's, I think we looked at that before, 27, or is it, it's the estimate from someone at D&D?
Yes.
Okay. And was that the estimate?
Oh my goodness. Wixom $2 late fee. I see it. Streamlabs will put it up shortly over there. And in the meantime, I will say thank you so much. That's going into the tree fund. One day I can afford a tree like that, lady. Right? Thank you so much. You're so sweet. Streamlabs!
Estimate to put in 3 arborvitae?
No,
No.
I talked with Amerilawn, who was our landscaping company, the HOA's landscaping company yesterday. I've just been talking with him because nobody else has spoken with me about this incident over the last several months. Nobody on the board or anybody in leadership has even said a word to me. So I've been asking him questions. I saw him installing a sprinkler there yesterday, which
That pushed it through. See how that came through first? And yet we're still waiting for the late fee. Not from you. You've paid it. It's now in limbo. Thank you for giving Lane a membership. That's so nice. Lane hangs out over in Credence and Mikey's chat a lot. Love it. This lady is giving me a very big Karen vibes, unlike Wixom. Unlike that. Streamlabs, I'm being serious now. Where's the super chat? I'm frustrated. This is being written down your permanent record. Holy fuck.
will be needed when they replant, I guess. So the other thing I wanted to point out is if you go to page 30, it appears the board has already attempted to cover up what actually happened to avoid.
There's a tree cover up. This lady who wants to oh, yay! Do 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 do. Oh, don't worry, Wixom. You're never interrupting. Ever, ever, ever. Thank fucking Christ that popped up. I was actually getting worried that we broke it, that the super chats weren't coming through. That's a bad day if that happens. Knock on wood, knock on wood. Anyways, so interrupt away. But now we have a cover up, ladies and gentlemen. Who fucking wants to bet that this is very well detailed on her Facebook page? That she's talking about her HOA tree cover up. Like, this is, you cannot write this. You cannot write this. Was it in here, Twitchy, Skitch, Streamlabs said some funny shit, or in another chat? Because that reminds me of a funny story I will tell you guys in a minute. But in here, if Streamlabs says it, you can... It's been said by one of us, most likely. When we have mods in here, like Jonathan or Sashina, they add commands. We have hundreds and hundreds of commands that we add often. So that's why you'll see some crazy stuff. Like if you type in ! links, you'll find all my links, even the adult ones. And if you type in ! gobble, that's one of my favorites. There's so many. In fact, give them a try.
Accountability. In the July newsletter, which was published in early July via email, after I filed this suit, the board wrote that some arborvitae shrubs, that's how they put it, needed to be removed due to overgrowth or disease. In the case of the ones on my property, that is false. They were removed because they were butchered and they're trying to cover that up. In my opinion, that's how I interpret what they said. I mean, if they're referring to the arborvitae trees on my property, they're lying. And I think my photographs prove that point. They were not removed because they needed to be removed because they were overgrown or diseased. They were removed because they looked awful, and the board is responsible for that. They're responsible for having, due diligence on doing a good job maintaining our common areas and my front yard landscaping. The second breach of fiduciary duty by the board involves choosing to.
Slow down.
Okay.
You know, what your claim is $2,500, and I'm still trying to get to the bottom of that. I think what it is to replace some arborvitae.
No,
The
I don't have.
allegations of violating fiduciary duties, this is small claims. It's not the other side of the house here where I sit as a civil law judge too, but this is small claims. And so you have to be able to show an absolute amount, a specific corroborated amount that you're owed. I'm just concerned that when you start talking about the violation of fiduciary duty, that's a whole nother animal. And how are
Is
you
that
gonna?
criminal court?
No, how are you gonna tie a specific amount corroborated by what you are out of pocket for? Small claims is very limited. So, just trying to hone in here. You're saying you're owed $2,500. How does the quote unquote, your belief that there's a violation of fiduciary duty equate to $2,500?
Well, they damaged my private property, and I feel like it's a fair remuneration.
Okay, so you just kind of, that seems right.
But the number came from a professional tree service.
Okay.
So I didn't just
that's
pull it
where
out of
we
the
are.
air. And the HOA has over $600,000 in assets.
Okay.
And I know it's coming from people's dues and so forth, but they certainly have the money. And I'm not.
They certainly have the money. Casey Carey, are you asking me how I keep so positive and nice? Aw. I'm secretly mean. That's how I do it. I'm actually a bitch. No, honestly, I laugh a lot and I have good friends. And you guys, you're my good friends. And I hang out with you guys every day. So I said this a little while ago. I feel like this is during the summer when you accidentally hang out with the same friend for like the whole summer every single day. And then all of a sudden it's the end of summer. And you're like, oh shit, that was the whole summer. I loved it. It's the way we do it.
Asking for $25,000. I'm asking for $2,500.
Okay, so you're tying that to D&D's
Estimate. Correct.
I lost that. 20. That's 29 in my, 27. Visited your property on
Correct.
5/28. In this person's view, it was destroyed, should be replaced. Verbal quote of 2,500. So is this your handwriting or
It's my handwriting.
Okay.
It's her handwriting, MB. Thank you so much for the lurking fee. I am sending positive vibes to you and your mom. I hope the weather isn't crazy. Also, ma'am, I think she is barking up the wrong tree. You know what I mean, MB? This lady sounds like she used to be the HOA. Who said that? She used to be the HOA and then got ousted. Like that Seinfeld episode. Oh.
All
I
right.
asked for a written quote and he refused.
Yeah, I can't, all right. It's hearsay. We don't have David Drury here. I don't know who he is. I can't establish his experience or the value of what he may have told you, but hearsay gets a little problematic because nobody can judge that. Somebody else's statement through you, and you know, there's no reason not to believe you, but a lot of times people get things misconstrued. Maybe it's exactly right, but then behind that, I can't talk to Mr. Drury and find out do you even know what you're talking about, or did you just start this business because you like trees? You know, and so that's difficult. But at least we've got a tie-in here. Now you talked about, you have a couple of things in here from your covenants and restrictions, I presume, or your bylaws. And we have this 31 and 32. What did you want me to take from those?
Well, they're responsible for taking care of the landscaping that was destroyed on my property.
Okay, are they also, that's what I'm trying to read here, is that maintain the exterior fronting on public right of way, that's up to you, maintain the public rights of way. And you highlighted something, maintain the landscaping and any irrigation systems appurtenant and any other improvements. And so that is attributable to whom, the landscaping, do you think?
Thank you, MB. Good night,
Well,
Loud. Good night,
It's
Beverly.
the HOA, it's the board ultimately. They decide who to hire to do that work.
All right.
And they've
Also, I wish we could time it next. If another super chat comes in, I'll time it because it's too long in between. It's unacceptable.
hired an outside landscaping company called Marilon.
And then section 9.02, repair and maintenance by owner, maintain in good condition, maintain an attractive condition near rear yard landscaping. So your sense, so I understand what you think. So you are fully in control of your rear yard, but it's got to look good.
Right.
That's what you think? Okay. And then the front and these are on the sides of your property?
The side front, which is again part of what the HOA maintains.
So you expect what? Your
Professional work.
but
done.
but your part of, what do you expect your obligations to those side lots are? What are your
I don't have an
obligations?
obligation except they're on my property, but
Okay.
I guess my expectation is the HOA will do their job and in due diligence, take care of the property. So it looks good. I mean, why do HOAs exist? They exist to keep our property values up, to keep our community looking good.
Yeah.
And this was, I would say, an anomaly. I've never seen anything like this before happen in 5 years I've lived there.
Okay. All right. So I'm getting what you're wanting me to take from those. All right. So before
Before they get going, we'll say goodnight to you, Sarah. I know the East Coast. I started late tonight for my East Coast people, but it's only 8 o'clock and these people are still stupid. But thank you for being here. Please like the video.
Can I make one last point?
Sure, that's what I was going to ask you before
Okay.
I turn to
Sorry.
Mr. Campo. What would you like to say?
Oh, okay, yeah, the last thing I want to say is according to state records online, the landscaping company is not licensed, bonded, or insured, and hasn't been for 6 years. And in the meeting minutes in February on
Hey bitch, Miss Carrie's here. Love it. Yes, late night on a Friday. We having a good night, Miss Carrie. And this lady's a bitch. As there always are. Oh yeah.
page 20, it's clear that the board knows that. They've known it since at least February. Joe said during mediation that the board has employed them for over 20 years. They've certainly been there in the 5 years I've owned my home.
So which company is this?
It's called Emerilon. I know, AMERI-lawn.
Just looking in your exhibit here to see. what you're
So
talking about.
pages 16 and 17 are what I got online from the state when I looked up the business, that they haven't been licensed for 6 years.
Do you know who cut down those shrubs or trees?
It was somebody working for Maryland. I didn't recognize the specific person that day, although typically I see the owner around and I see another one of his employees that I've seen for years, but that person was not familiar. who's probably been let go because they did a terrible job and I have not seen them again.
Karen, your privilege is showing. You think that you calling the company one time caused this person to be let go, allegedly, because they didn't come back. Why the fuck would they come back to your house? Just the privilege. Her privilege is showing. Oh my God.
So how, you're presuming or you know that it was a Marilyn?
I'm 99% sure it was.
Because why?
Because I see their trucks and I see them around
So you saw that.
almost every day.
Okay, so the day that those trees were cut down, their trucks were in your neighborhood
Uh-huh.
and someone's there. Okay, got it.
They're almost every day. They're there, sometimes 6 days a week, actually.
Okay, have you ever put in any similar arborvitae's on your property before, in the backyard, anywhere?
No, I don't have any planted in my garden.
Okay, all right. I was just asking to see if. All right. Anything else before I turn to Mr. Campo?
Nope.
Okay, all right, so Mr. Campo,
Take it away.
your response to this request that the homeowners association owes Ms. Robinson $2,500 for those trees that were cut down, I guess that's where we are.
I'm not really sure how to respond to that, Judge.
We've got lots of exhibits that you filed here, and so you're saying the homeowners association has authority over that front yard and not taking up anything about market value. I think we've narrowed here in on this $2,500 to these trees that were or whatever they were, shrubs, trees taken down to stumps that we have pictures of. Is that, do you disagree with that happening, or, you know, you can tell me about that?
Would it be okay to just let you know what I know about this?
Well, that's exactly, I would think, why you're here.
Okay.
So on behalf of the homeowners association, why doesn't the homeowners association owe 2,500? I guess it's.
I became aware of this situation when Miss Robinson sent an email to our chat line. We have a community chat line.
Mhm.
And I looked at it and didn't really understand what the issue was. So I went over to her property and looked. Then I talked to the landscaper and said, why has this arborvitae bush been pruned in the way that it's been pruned?
So this was when the pruning was happening, not when things were cut down.
Correct.
Okay, so at that stage.
Yeah.
All right.
He said, and I saw, the middle of this bush is all dead. So you have to cut away the top so the sun and the rain can get in there, and they call it rejuvenation pruning. And it looks terrible. So I said, look, your purpose here is to make the community look good, not to butcher these. How long will this look like this? He said, a year, maybe 2. I said, no, fix it. It's not acceptable appearance wise. And because the homeowners association bears the cost for all that.
Okay.
And our purpose is, as Ms. Robinson has just said, to make the community look good. We didn't want that. So I said, whatever you have to do to make this look better, that's up to you, but fix it.
Okay.
So he decided to take it out. That's when they became stumps. They leave those on purpose just so they can pull them out of the ground later.
Okay.
They actually chain up to those stumps and pull them out. And what follows is replanting, which again is done by Marilyn, the contracted landscaper for the HOA. Even if she gets an estimate from another service, they have no authority to come into the HOA and do anything.
Okay, as to that area.
Yes, because per the CCNRs, the HOA has sole authority over the front yard maintenance. That's cutting
So
down
you-
trees, everything.
You supplied the same, I mean, you both supplied the same portions, I think all the same portions of the CCNRs, Article 9.
Yeah.
And you both referred to the exact same places. And so I'm to take from that, when I look at Article 9, repair and maintenance, section 9.01, sub D, as in dog, that the HOA, and I think that's understood here, both of you say that, maintain the landscaping and any irrigation pertinent thereto, and any improvements located within those portions of the lot described on Exhibit A attached here too. And so Exhibit A, that was that provided, maybe, I don't know if anybody provided me Exhibit A, but I did have a couple of schematics in. Yeah.
Oh, thank fucking God. Erica woke me up out of my little bit of a daze. Thank you so much, Erica. You're so sweet. Happy Friday to you too. Woo! Wake up, Paisley. I think this hurts my head. It puts me, I like the look of it. It hurts my head. It's like a cat being like held on the back of the neck. It's like hitting the back of my head. Thank you again, Erica. Welcome, Eileen. Yay, members only Sundays, every Sunday.
Here's Exhibit A in the plaintiff's exhibits, and it's highlighted there. Your lot is 196. Okay, and it's highlighted there, and those are the responsibility of the homeowners association. And you had a chance to look at everything too. Looks like the side yards, front yards, I would call them, where these arborvitaes are, right? Okay. So what's happened since, I mean, they were cut down sometime in June, and then what's happened since?
They're just waiting for, you don't really want to do replanting in the midsummer. So there are arborvitaes, depending upon what condition they were in, some were taken out all over the HOA. And they will
These are
be
your tax
replanting in
dollars,
the
ladies
fall,
and gentlemen. Tax dollars.
which is the, what goes in there is flexible. They usually talk to the homeowners, say, here's what we recommend. Do you have a preference? And the HOA will take care of the cost of the replanting, and that will be that.
Okay, and so there are other properties, as I've heard, had this similar thing happen. And that's the point. That's
well, we don't have any. Ms. Robinson's the only one who registered a complaint via the chat line.
But pruning, chopping down, replacing.
Yeah.
All right.
Yeah,
that's what's going on.
We have 223 homes, and so there's all over the community that if they're a healthy bush, they can just be trimmed. If they're dying in the center, they mostly have to come out.
So I'm looking at what was filed by Robinson here. Let me get there. Reflecting just that. I think that's, yeah, the kind of newslettery looking thing, Breckenridge News e-blast. Okay, so talking about pension. Where was that? Something was going to be happening.
Page 30, I believe.
Have you found some mounds of dirt? Okay. New landscaping through removing a rhododendron arborvitae that either have become too large. All right. Okay, so therefore, Mr. Campano, on behalf of the homeowners association, you don't owe $2,500 to Ms. Robinson because this is the obligation of the homeowners association and they're paying for it.
That's correct.
And Ms. Robinson you're saying, wouldn't be allowed even to have any other company come in and put in anything in that spot.
Yes, Judge, that's also correct.
Okay, she could do whatever she wants that's attractive in her rear yard, but not in those spots. Okay, so you're saying that she won't be out any money because the homeowners association is going to make sure that gets done.
And by the time we finish our job, she'll have healthy plants there. I don't know what they will be, but what she had and what was removed. And by the way, Her next door neighbor had one that was also removed. We talked with him.
That's okay. I don't need to know
Yeah.
about the next door neighbor.
Yeah, the new ones will probably be, maybe a foot or two tall.
All right, so
Who knows?
Mr. Campano, anything else I should consider from the homeowners association?
No, only to the extent that we want to, when we replant, we want to do it at a time that the plants are going to be healthy and grow, which is not midsummer. And it may not be arborvitae, and probably will not be arborvitae that goes back in there. They tend to get too large for most of the spaces that they were originally put in. And they become a real problem with maintaining. So it's likely to be something else.
And so you've been working with this Amerilawn, or the homeowners association's been working with them for how long?
It's over 20 years. The homeowners association actually helped the owner of Amerilawn establish the company.
Okay.
One of our former board members worked with him to help him put the company together.
Oh, don't say that. She's got a conspiracy theory about that. She has a conspiracy theory about it. Dude, oh my god. Wait, so does the HOA own the company? Oh my god. Also, Vince, sorry that you were sleeping and woken back to sleep.
And so he and his company's been servicing your homeowners association, and you kind of say, do what you need to do to make it nice.
We have a landscape chair who's in charge of working with him, and she works every day with him, goes out and looks and sees what he's doing. And
Is the homeowner?
Yes, it's one of the
What's
homeowners.
that person's name?
Oh, just slow down. I'm talking to him. You're
Sorry.
not talking to each other. You do this like this. All right. It's not, all right. So, and there's a landscape chair, and you look to that chair of that landscape committee to see that it's done within constraints of your bylaws, or
Yes, it's the chair right now is a lady who, if she runs into an issue that's problematic, then she contacts me as a board member. I go out all the time and meet with homeowners and resolve issues.
well, all right. I'm just going to jump back quickly to Ms. Robinson after hearing from Mr. Campano. Anything else that you think I should think about or no?
What he just said was he go out and talks to homeowners when there's problems. No one ever came and spoke with me, Mr. Campano, or the landscape chair, or anyone else, or ever responded to my emails and knocking on people's doors. So I never heard a thing about this issue. No one ever seemed to be concerned or would even acknowledge it existed. So what he said may be true, but it wasn't true in my case.
Okay. Yeah, that seems to be the biggest problem here, frankly, is just communication and feeling of being left out a bit on what's going on.
That's, Judge, that's
and
based on history.
Right. What I'm dismissing your claim because there's not evidence sufficient to find that the homeowners association did anything on property they weren't allowed to do, and that you're not out. I can't find any evidence that you're out $2,500 in any way. And it does seem like maybe it sounds like you're moving on from this homeowners
Right.
association, but communication usually is what gets people into court. And I don't know, maybe there's some way to find a better way to find out what's going on, or better way to let everybody know what's going on. I don't know, but that might have stemmed the tide of all of this.
Absolutely.
Yeah. So anyway, so that's where we are. Kind of had an airing of it. Yes, I would
Do you
presume
feel
in the
better with
fall
your
at some
bush air
point,
out, lady?
something's going to get put in, because that's always a good planting time in this area of the world. And good luck on the buyer and finding a nice new home. That's all for today. So we can give you copies of this. I should, oh wait, I forgot to mark the box. Wait.
She aired
I
out
love
her
my
bush
home, but I'm
grievances.
moving because I don't like my HOA. Yeah.
We know,
it's
ma'am.
just- That's how it is.
Oh, there you go. We'll get you copies of this and then you're on your way.
It's the first time I've lived in an HOA. They come with issues.
Yeah, you have all the power and I have none.
Okay, come on up here. and Suggest you don't. Yeah, thanks. All right, so welcome. You can be on your way. He's got your copy there and you can be on your way. All right, so let me.
Thank you for listening.
Sure. All right. So
Judge,
we've got
what is going on?
and Mr. and Joel Ramos.
Yes, hello.
Hello, how are you? Fuck, that lady was not happy. Proof's in the pudding, lady. Go ahead and move. That would be great. Everybody else would be happy too. And what else? What have we got here? Also, if that's a candle holder, don't light candle holders like that are on your wall, because they can light your walls on fire. I know that goes without saying, but just in case.
Yeah, Joe, if somebody contacted me.
You know, I'm on record. Please be quiet. I'm trying to start another hearing. Thanks. So, Ms. Moran, is that how I say your last name?
It's Maureen.
Maureen, thank you. All right. And then Mr. Ramos.
I'm here.
Let me get you both under oath here. Ms. Maureen, if you'd raise your right hand with me, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
And then Mr. Ramos, raising your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You do? Okay. All right.
do.
It's a little delay with you. All right. So we're here on case number 37357. And let's see, do we still have, I'm just going to kind of check and did we get folks back on number 9 or have they continued to disappear?
They have just disappeared. I don't have, I haven't seen one back in.
I'm going to jump to something else to make sure people aren't here for no good reason.
Disappearing.
Huh, they were here.
What is in the cage behind him covered with a
Oh,
towel?
okay.
Is it a bird? Is it a rat? Is it a hamster? Is it a cat? Is it hats?
All right. So, Mr. Spreen, is it? Mr. Spreen, are you still with us? It looks like he's gone too.
Yeah, both parties. in the case are
All
gone.
right, well, it's 11 o'clock. So I think what I'm going to do here is on 37364, dismiss the claim. We had them here and then they both left and it's 11 o'clock and court's been in session for about an hour here. Well, for the whole time. So get that dismissed.
Judge, when are they gonna be done? When are they gonna talk? Oh, they're gonna talk pretty soon. She's gonna come to them soon. She's gonna lift her hands up like this. She's gonna say hi. And then that's what's gonna happen. I don't know what's in the, I think it's a bird too. My first thought was bird. Oh, here we go. Hands up, hands up.
All right, so sorry, folks, back to Ms. Maureen and Mr. Ramos. So we're here on 37357, case filed by Ms. Maureen, and I'm looking back and forth. I have a couple of screens up here. I'm looking at my court file, which is electronic, so I am listening, but I'm also looking at things that everybody's filed. And we've got a claim by Ms. Maureen and a counterclaim by Mr. Ramos, and it's about, let's see, a property here in Thurston County. Looks like, Ms. Maureen, you were a tenant at one point of your landlord, Mr. Ramos, and Joel Properties, is that right?
Yes.
Okay, so I got it straight. And you're saying, and I'll open also the counterclaim. Get these both open. You're saying that you're owed about $2,400. We're in a turn of deposit in last month's rent. And then Mr. Ramos says he's owed about $1,200. I'm rounding here. We'll get to particulars later, but about $1,200 for additional cost after applying your deposit to repair damages in the rental. So, all right, I think I've got the timeframes right. You started a tenancy September 1st of 2021. You think you left by March 31st. Mr. Ramos is saying April 1st. That seems to be the first dispute. Is that correct?
Yes, and I was completely moved out on April 1st. So the last month's rent, I'm not asking for that anymore.
Okay, so what's your claim? What are you asking for?
This return of the security deposit.
And that would have been what, how much was that again?
$1,231.
Okay, now, and you gave that at the beginning of your tenancy. I'm just kind of looking at all the whatever exhibits I have here.
There's a bunch.
Yeah, give me a moment. So. So I'm looking into your rental agreement and you says security deposit of $1,231 and you paid that to Mr. Ramos at the beginning?
Yes, and I actually was on the HEN program, Housing and Essential Needs, and they pay all move-in costs and rent. But when you move out of a place, the deposit, if there is any, it gets returned it would have gotten returned to me. So I just wanted to clarify that real quick. But yes, it was paid to.
So did you pay $1,231 to Ramos?
It was paid, yes.
It was paid by HEN?
Yes.
Okay.
Yes. And HEN has told me that to pursue this because when I move out, the deposit gets returned to the tenant, not back to the HEN program, which is why HEN is not here doing this.
Okay. All right. So,
and also, I'm sorry, in the rental agreement, it does say that any payments, made by anybody other than the tenant doesn't constitute, a contract between the person who pays and the landlord. It's still between landlord and tenant.
And where do you want me to see that?
It would be on page 8 of the rental agreement. And it's about halfway down. It says payments from tenants or from non-tenants.
Okay.
I think that actually makes sense. You can imagine if you're a community organization and you are paying somebody's moving costs up front, including their damage deposit, but you want to incentivize them to treat the place appropriately and nicely, then the best way to do that would be to tell them that they could have the damage deposit back at the end. Otherwise, it would be hard, and the money is already expended. So what's the difference? It sounds like actually a good and smart way to do it. I know the judge is a little bit disbelieving, but I think that makes a lot of sense, especially since it's long-term money. Even if it's grant money or whatever, that money's not coming back ideally for years, probably. If the person's housing is stable, you know what I'm saying?
So HEN paid this and you're asking for it back, and that's your understanding that it should come back to you from HEN. All right, and they're not here. All right, so
And then why do you think you're owed that?
Because when I moved in, and there's pictures that I submitted of the condition of the trailer when I moved in, that I had to clean up after, and those pictures start on page 24. And that was the condition when I moved in. I had to clean all of that up. There was no condition checklist or walkthrough done when I moved in between Joel and I.
Know why you didn't do that?
Honestly, I'm not sure. Yeah, I'm not sure why.
Would that have been done with Hen without you knowing, or how is this
No.
place found?
No, Hen said that they usually try to do a walkthrough when somebody moves into a place, but it's not like a requirement or anything. They had me do the walkthrough, and I told them, what was wrong or what needed to be fixed, and gave that information to Joel. But there was nothing is done with Hen other than they pay the rent.
Okay, so you did do a walkthrough on your own without Mr. Ramos.
Yes, so that I could tell him, what was wrong and what needed to be fixed before I moved in. And some of the things were fixed and others were not.
And you still moved in?
I had no choice. I needed somewhere to move into, and I cleaned up, what was left, the condition of the trailer that was left in when I moved in. I cleaned up, that was no problem. But it was an immediate thing. I needed to move, somewhere because my place that I was living before that, they were selling the property. So I needed to move right away. But yeah, there was no condition checklist done or anything. And Hen encouraged me to pursue this. When I moved out, I didn't receive any, itemized.
Help me understand that then. You're moving out. How did you tell Mr. Ramos that you were moving out?
I believe I sent him a text message on March 18th.
March 18th. And do you have that in your exhibits here? Can you just tell me?
I do not, but I think he will confirm that.
All right. So text message to Mr. Ramos on March 18th. And what did you tell him?
That I was moving out and that I would be out by April 1st, I believe, is what I said. And I was out on the 1st. Completely moved out.
Okay, and you were out on the 1st. What does that mean to you out? So
how
did he know?
I had all of my stuff moved out, and I did clean. I cleaned the carpets, the floors, I cleaned up after myself. I left a carpet shampooer there for the park manager because it worked and everything, and she said she wanted it, so I left it there. And I left some other stuff there that she had said that she would take and wanted to keep. But other than that, I cleaned up and got all my stuff moved out and was done with that on the 1st of April.
Did you go to Mr. Ramos and say, I'm out, or how did he know you were out?
I was actually dealing with the park manager on that. And I was told to leave the keys. And so I did. I left the keys and she took it from there.
Okay, so you left the keys on the 1st?
Yes, on April 1st.
With who?
Her name is Dee. I'm not sure of her last name.
And you think she's the park manager?
Yeah.
And how long so you were there about a year and a half?
Yeah.
Almost. Yeah. And so you dealt with her throughout that year and a half?
Most of the time I did go directly to Joel with a few, important things, but yeah, I mostly dealt with her because she lived on site.
Okay. And so your agreement, I'm looking at the lease, was.
I'll just say this, where I live, there are very strict rules for return of damage deposit. If there wasn't a walkthrough done at the beginning, he can't keep her damage deposit because he doesn't have the original walkthrough that they both signed in order to prove it. And you have to return it within a certain amount of time. And if you don't, you're entitled to many times the amount of the damage deposit. But the problem is this, it's very difficult to navigate the residential tenancy branch, which is who arbitrates disputes in my province. This is small claims. It's different. That happens through the tenancy branch to relieve, you know, the difficulty on the justice system. And so it's still very difficult, though. Even emergency situations take months and months to handle. And so it's a difficult process, but he wouldn't be able to keep her deposit for months and months. He would be in quite a bit of shit, especially if he didn't do the walkthrough ahead of time. He really doesn't have a leg to stand on with the damages, because how does he prove that it wasn't, you know what I'm saying? So that's really his bad. And I mean, she should have maybe made a video the day that she moved in with him, that she could show, and then she needs to say, I left it in better condition than I got it in. But
Is month to month, is that correct?
Yeah.
All right, and then you started the 1st of September.
Paul, we talked about this. The money is a grant from that agency, and I think that it makes sense. Agencies that provide immediate housing support for people in need tend to have funding issues, obviously, but they need long-term stable funding. They can't be relying upon somebody chasing down all of those types of little deposits. It honestly doesn't make monetary sense. What makes more sense is once you've decided to output that cost on somebody, you apply it as a grant, and like I said, you inspire that person to treat the property well by incentivizing them to get that deposit back at the end. I think that makes for a better relationship all overall, and it makes more sense administratively. Because they don't want to be responsible for the rent, so they don't want their name, or maybe they are, but do you know what I'm saying? Like, anyways, let's continue.
September, and okay, and then so I'm looking at the lease here, and so then by April 1st, Mr. Ramos would have had the keys through his park manager, and you were done.
Yep.
All right. So I'm looking at the lease that you filed here and asking for 20 days written notice is required. And this was 14 days.
Which is why I'm not asking for last month's rent anymore.
Okay, I see. All right, and so you believe that you should have that deposit back. Why?
Because like I said, the condition of the trailer when I moved in, and after moving in, there was a wall where an addition was built and then torn down, and then a replacement wall was built, and it was held together with staples and caulking and paint, and just yeah, a lot of the things were wrong with the trailer, but it was actually brought to my attention that the trailer might have been rented to me illegally because of that unpermitted construction of that wall being rebuilt. And Hen actually told me that. But you know, I brought this to Joel's attention because the power bill was really high, and I was not, you know, I didn't get a response from him. But I believe that the condition or the deposit is owed to me because of basically the condition of the trailer when I moved in. Yeah.
All right, so let me ask you about when you got out, did you contact Mr. Ramos? Did he contact you about doing a walkthrough?
No.
No. And so you sent the text. There's a manager on site that you've been working with, but you sent the text on the 18th. I'm going to be out by the 1st. What happened between March 18th and April 1st between you and Mr. Ramos? Anything?
I sent him an email. Let me find it. I believe on March 20th, regarding the issues that I had with the power bill being so high in the wintertime because of no insulation.
5 days before my birthday, March 20th, you'll find
where that addition was built and torn down, and just a couple other issues. And I never got a response to that email. I'm looking for my, oh, there it is. And that email would be on page 19 of the stuff I submitted. And I didn't ever hear back from him on that email. So there was not a whole lot of communication between Joel and I between March 18th and April 1st. I was mostly.
Okay. So that was the only contact that you had. He didn't contact you about, we got to do a walkthrough, we got to do this, we got to do that. I need the keys, anything about
He
moving
did.
out?
He did send me a couple text messages like, "Hey, how's the move going? Do you have everything? You know, are you on schedule?" And to which I did respond to those. You know, yes, everything's fine, everything's going good. But other than that, no, I don't believe there was any communication between him and I. Other than that,
Did you, all right. And so you just kept moving your things and then you were out by the first, left the keys. You didn't look to get a walkthrough done. You did your own walkthrough coming in and sent him notice of some of the things you thought were wrong, and he fixed some of the things, not all the things that you thought were wrong, and then you moved in. Okay. All right. Did you, all right, so after you're out, April 1st, how did you find out or not about what was going on with your deposit?
Well, I never heard anything, you know, from him. I did not hear anything about the deposit until I contacted Joel in July of this year, because, you know, I am no longer on the hen program, but I still communicate with, you know, my hen worker because of, you know, all this. And she encouraged me to, you know, pursue getting the deposit back, because I had not heard, you know, anything from Joel about why he was keeping the deposit. And when he found out that I was taking him to court for it is when I found out why he was keeping the deposit and that he was keeping it. And also that I owed more for damage.
So did you give Mr. Ramos a forwarding address of any kind or a way to contact you?
My email and my phone number is exactly the same. He knew he could have gotten a hold of me had he wanted to.
All right, so that hadn't changed from April 1st. Email you could call.
Nope.
Or text, sounded like. But no forwarding living address yet.
I am not 100% sure, but I think I did leave an address with Dee, the park manager, but like I said, I'm not 100% sure, so I can't for sure say yes or no.
Okay, all right, but you were certain about the email and the phone. Okay.
Absolutely, yes.
And then, so you didn't hear anything back, and so April, May, June, so finally by July, you're wondering where your deposit is.
Yes, July of this year. It's been almost a year because I didn't, you know, I was trying to figure this whole thing out with Hen, whether or not we wanted to like take him to court for more, you know, for it being rented illegally and so forth. And
So, did you know when you moved out that deposit was coming back to you?
Yes, I knew that it should have been, yes.
All right, and Hen didn't go back to Hen and?
No.
Okay, all right. So a year and a half later, right, I got my dates wrong here. That's when you started to question where the deposit was.
Yes, because my hen worker had encouraged me to pursue getting it back.
So any discussions, you filed on July 2nd, so you didn't have any discussions with Mr. Ramos since?
Yes, I did. I actually emailed him. Then the email conversations they start on page 10. And those start in June, on June 21st.
This year? This year?
Of this year, yes, of this year.
Okay. So that's when you really started saying, what's up? All
Yes.
right. Yeah. Okay. And you didn't I just see your emails. Did you get responses?
Yes, they're on there. They're also, the whole conversation goes in order. If you see the first two emails, there's little lines underneath. Um,
Yeah,
yeah,
there you.
yeah. And those those are pages 10 through 14, I believe.
Okay, so that was Saturday, June 22nd was kind of the guts of it. Asking for the deposit, it's only fair you're also responsible to pay the additional cost, and here it is, and his offer of 4 monthly payments to get up to $1,200 some dollars. And he's asserting that vacating, all right, so you give it up, all right, that's right. All right, so anything else before I turn to Mr. Ramos?
Now when I did contact him in June, he did send, when he was saying that I owed the damages, he did attach a letter, which is also in there, on page 17, I believe. He said that he sent a letter to Hen, saying that, you know, I owed for damages. And that was shortly after I had moved out. But I didn't ever receive anything from him, and Hen, all they did was pay the rent. But yeah, other than that, no, I think that's everything.
Bitch, all they did was pay the rent? Let me tell you something. If all somebody does is pay my rent, I'm treating them better than that. Also, we can tell Paisley doesn't have a date tonight because that is roasted garlic, by the way, and I'm just ate 2 cloves of it straight. Oh, I love it.
And like the pictures of the condition when I moved in they're all in there and everything.
All right. All right. Well, Mr. Ramos, so we now know that Ms. Maureen is asking only for the deposit of $1,231. She's not asking for last month's rent. She agrees there. So, and then you are asserting a counterclaim here about $1,200. So if you could answer both of these issues, first off, the deposit and then the $1,200 some dollars that you think you're owed, and your response and your counterclaim. Go ahead.
Yes. So when Danica left, right, I've been receiving payments directly from the HAND program. I'm not contesting that I did not send them the bill for the repairs. I sent it directly to the HAND program to try and recover the cost of the damages incurred using the unit. So, if you look through, what is it, Exhibit C, you can see the email that I sent to the HAND program explaining how I came to the total damages and what's owed after subtracting the deposit.
Where am I looking again? Oh, there it is. Okay, C
in the counterclaim.
Email to
Exhibit
Catholic
C.
Community Services. Okay, so that was April 21st. All right.
Right. And then the next couple of pages is just the breakout of materials and labor.
All right, so so you sent this accounting to Catholic Community Services instead of to Ms. Maureen, and that's all right.
Correct.
And then what came of that when you did that? What happened after that?
Nothing. I didn't hear back from them, so I just took it as a sign that I was just have to absorb the difference between the cost and the deposit.
So Catholic Community Service didn't respond in writing, email, phone call? No way. They just dead space, a dead air. Okay. No. So that was all right. And then at that point, So, and you sent it to Catholic Community Services Y as opposed to Ms. Maureen.
Oh, they run the hen program, and like I said, they've been paying for the rent the whole time. I didn't expect to get anything from Danica because she wasn't working. So my best chances was just go through the program directly and see if I can recover some of that cost.
Okay, and then what I was, the lease that was in Ms. Maureen's exhibits, is that, do you agree that's the lease that you were working under?
Yes.
Okay, all right. And all right, so this is between, well, Joel Properties, and you're the principal of Joel Properties, correct? You're nodding yes?
Correct.
Okay, all right.
Yes.
So this is saying it's between Ms. Maureen and you, but the hen, there's nothing in here about hen paying rent, or is it in here somewhere? I mean, there's an allowance for a third party to do that, but you don't.
It is not in the lease.
Okay. And then there is that allowance in there, though, protective allowance for you, that even if someone does pay, that doesn't make them part of the tenancy. Let me get to that. I have to read that again. It's pretty common language in these. Where is it? Payments from non-tenants, acceptance of any check drawn on account. So you accepted any of those appropriately. Payment made by others shall not construe as creating a tenancy or a contract of any kind with that person. They're only construed to be made on behalf of the tenant. So in your lease, you're saying that all those payments from hen are not creating a contract or a tenancy with them. It's all just taken as on behalf of Ms. Maureen. So, okay. Then, all right, so nothing from Community Catholic Services, and then here we are about a year and a half later. What's happened in the meantime then, and why do you think you're owed $1,200 some dollars?
So I like I said, didn't hear from the hen program. I just wrote it off. It only resurfaced when Danica approached me, claiming that I owed her the deposit and the last month's rent. And I explained to her, well, the reason why I didn't give you your deposit back was precisely what from the damages, right?
Okay.
So, I'm only doing the counter suit because of her bringing this one up. Like I said, I was fine just absorbing it, treating it as, a cost of doing business, right?
Yeah.
But if she wants to go down and go through this legal proceeding, then I think it's only fair that I can come back and request the money that's owed.
And
so I'm talking to Mr. Ramos, so don't say anything, Ms. Maureen.
Yep.
So let me, Mr. Ramos, kind of go back to how you started this tenancy. Did you have a written lease here, and I see what the deposit's all about, and this idea about a walk-in and a walk-out, what happened there when you first started with Miss Maureen? She said, you heard her say that she said she kind of walked around, made a list, gave it to you, and you fixed some things. And so what happened with the walk-in or portion of this? What did you do?
So so part of the hand program, what they do is they have certain standards of the condition of the units. So they would not, if the house was not habitable, they would not allow the tenant to move in, sign an agreement, and pay for the rent, right? So it's just part of their program, right? So
did you have hen folks
I
come
remember
through your property? Did hen folks come through your property at some point and say, "A-okay"?
No,
You
so
know?
the Danica and through they were supposed to go and do the walkthrough together.
Okay, so you understood that Ms. Maureen and Catholic Community Services, who runs HEN, were supposed to do that walkthrough. Okay. And then so was there ever any kind of walk-in checklist or anything that you received or you shared with Ms. Maureen or talked about with her?
You mean as far as what repairs are needed?
Well, no, when you first started the tenancy, did you walk through with Ms. Maureen or have her walk through and, check off the condition of the premises? Did you do that? Okay. And you did that with Ms. Maureen?
We did. We when I first met her the first time, we did a walkthrough together where I walked through the unit with her, and I told her, like, we're going to be doing this, we need to do that, right? So we did that. I didn't put anything in writing as far as like a checklist, right? But I basically said, this one's going to be done before you move in. We're going to do this. We're going to leave this as is, right? So there shouldn't be any surprises on the condition of the unit is going to be.
Okay. And then when she left, she says she turned the keys into your manager, your park manager, on April 1st. Is that what you agree is how you got back the unit? When did you believe you had the unit back?
That sounds about right. I requested my park manager D to do a walkthrough with her because I don't live in the area.
Okay.
So I'm not sure if it was like handing the key to D or leaving it behind. I'm not sure what happened, but that's one of the things I asked for, make sure happened.
Okay, and then so a walkthrough, you think one of your D would have done that, and all right, and put that to writing, but I don't have any of that, and you don't have it either? What D did?
I don't
You
have
know?
anything from D. I can get something from D.
Okay. Well, we're in the midst of trial. It's a little late for anybody to start saying that, but
yeah.
All right. Anything else? I've looked at your exhibits. I looked at Ms. Maureen's exhibits. Anything else you want me to know or look at or say?
Oh, sorry, go ahead.
Just one thing.
Ms. Maureen, I'm talking to Mr. Ramos, so let him just talk.
Yeah.
So just one thing. Danica, so for me, here's the bottom line. Danica did not experience any financial damages, right? So HEN paid for everything. HEN paid for the rent, her utilities. She's not out any funds. The HEN program even paid for the deposit, right? So meanwhile, the repairs caused by Danica, after the year and a half that she was living in the unit, came to the $2,400, right? That I'm asking, that I showed in my counterclaim. So in the end, after I took out the deposit, I'm still short $1,200, right? So I'm from my perspective, the HEN program paid the deposit. She never put any of her money in, so that there's really no financial damages that I've caused to Danica.
And so when you received that $1,231, you got that from Catholic Community Services, you're saying?
It was the Catholic Community Services was the second. It was a different organization that was running HEN when Danica first moved in.
Okay, but you received it not from Ms. Maureen, but from some other agency.
No, she never paid anything. No first month, last month deposit, no rent. It's all from the
So
HEN
that
program.
so you got a check or something remittance from some other agency. All right.
Correct.
All right. All right. Let me just briefly turn back to Ms. Maureen. So Ms. Maureen, anything you wanted to
yes.
say once you heard this?
Yes. Now, while it it is true, yes, that Hen did pay, for the move-in related costs and everything. They are the ones who have encouraged me to pursue getting the security deposit back, because when a tenant moves out and they are on Hen, the security deposit goes to the tenant. And with, just the overall condition of the trailer, there's, like the issue with the wall and everything. That's why they've encouraged me to pursue this. And the walkthrough that Joel and I did, it was when he was showing me the trailer. It wasn't a condition walkthrough or anything. It was just, he was showing me the trailer. And, there was, things that needed to be fixed. And that's when I told him I would talk to Hen and get back with him about the stuff that they needed repaired. Hen does not require a walkthrough. They do not require, like, they don't come and do walkthroughs to places that are, potential rentals. They try to, if it, like if it's a trailer and it's older or something, they do try to, make sure that it's not like has lead paint or whatever. But it's not something that they require before paying rent or move-in related costs.
All right. All right, so yeah, a couple of things going with the claim from Ms. Maureen about $1,231 for the deposit, and Mr. Ramos damages that come out to $1,200 after you use the deposit as part of that $2,400 some dollar damage. So I'm dismissing both your claims, and this is why. I'll map it out for you. First off, Ms. Maureen, you can't really prove that you're damaged here to $1,231. It was paid by a different agency. Maybe Hen has an agreement with you, but that's not Mr. Ramos's issue. Maybe it's Hen should pay that. I don't know, but you being damaged, since you didn't pay this, there's no proof of damages that this court can award. The counterclaims, Mr. Ramos, to Ms. Maureen as part of this lease, when she told you she was leaving, then the clock starts ticking once you get possession, and you say you had possession of this place April 1st. And there are some exceptions if you needed more time to figure out what possible damages are, but there has to be a written walk-in checklist that both of you go through together to establish what the place looks like. And then you all sign off and everybody has a copy. And then everybody lives there. And then afterwards, there has to be another checklist walk out to say, what does the place look like? You may not agree, but at least everybody has it. We don't have either of those. The law says you got to do that. And then you have a certain amount of time. Looks like you sent it to Catholic Community Services. But she's the tenant. And so she needed to get this run down in a particular amount of time. A year and a half later, we're starting to do that. So the way I interpret the law says that then, since the particulars under the law, you had a written lease, you had a provision in there about what the security deposit was, you didn't have the walk-in or walk-out, and that's the problem. So therefore, the law says you're barred from asking for any damages. So that's why I'm dismissing both these claims. And in small claims, that's the end of both of your claims. So we'll have this dismissal in the court file for both of you. And that's it for today.
Okay.
So
Thank you.
Thank you.
Both be on your way. And then we're gonna have to just find a new time.
Oh my God. She crushed all the dreams today, you guys. She literally did. She denied here, denied there. Big D, big D, big D. Speaking of big D, tomorrow night, 8 p.m. Eastern, is going to be slap fights. We're going to do something pre-slap fights. So look for that. I don't know what, but I'll post it tomorrow. And join us tomorrow evening for slap fights. It's going to be a blast of a time. Blood possible. I mean, melon juice. You know what I mean. Hi, Vicky. Look. Finally, the things came up. Anyways, I hope that you guys had a wonderful evening. I did. It was so great. Let's do it again tomorrow, shall we? Yes, slap fights, dick slap fights, maybe. Eggplant. Hit the links, exclamation mark links. I did post some new content over on OnlyFans. Shameless plug. I hope that everybody has a wonderful Friday night. Don't get ahead of yourselves. It's Friday night. I hope you have a wonderful one. Thanks again for being here. Remember that I love you. I'm proud of you. And I will see you in the next video. Bye.
Ways down red.